Hello, dear partners. The topic of today's video is the buyer doesn't pay the delivered goods. This is often a question which we hear in our company, in our legal office. What to do if partners doesn't pay the delivered goods? Foreign suppliers of goods to whom the Russian buyers don't pay often address us such request. In this video I will tell how to collect money from the Russian companies according to the delivery agreement goods for unpaid goods. Suppliers often come up against a situation when goods are delivered and the buyer didn't pay the money. This standard behavior for the unfair buyer, of course. What financial sanctions can be undertaken concerning the unfair buyer who received but didn't pay goods? First of all, it is necessary to make to the buyer a complaint or pretension. Filing a complaint means your readiness, means you're ready shortly to take legal action for the buyer. Each partner, your partner, understand that the claim is not obligatory for execution. However, together with it, also the fact that the supplier is going to take legal action shortly is clear. Generally, claims are written for this purpose to intimidate the partner, to show him that you are ready to act and you are not going to wait more. And this is one of reasons. Often happens that the partner receiving requirements of the supplier and pays debt, or its part, or gives the written answer why, according to his opinion, the goods should not be paid. It is anyway good result because gives for you the idea for further action, and it is possible to decide on the position of the buyer. For example, if the buyer made partial payment of goods, then it essentially says that the buyer does not dispute the fact of signing of the contract of delivery goods received and the obligation of a payment of goods. The main objections of the buyer in that case is the fact that goods are delivered in inadequate quality, or goods are delivered out of time, or shortage of goods is allowed. Proceedings from actually current situation, it is necessary to develop a position the buyer disproving arguments, or if objections of the buyer are true and are incontestable, it is worth discussing versions of the voluntary settlement for minimization of mutual expenses. Example of the contractual claim of delivery you can download on our website also. How to file a lawsuit to a court, a lawsuit about the collection money from the supplier. If the claim stage of receiving debt didn't help, or helped not completely, then it is necessary to take legal action for requirements about debt collection. I think you understand it. And appeal to the court is fraud for debtor with collecting not only debts on payment of the delivered goods, but also penalties, collecting percent penalties, court costs on the lawyer, and paid state fees. Beside this, If the delivery agreement is signed at bidding, it's a federal law number 44 in Russia. Judgments on debts collection for the delivered goods are extremely not desirable for the supplier, since it can threaten the buyer with inclusion in the register of unfair partners. You can look at an action of declaration some example in our following action, in our following article, also on our website, which names action for declarations example in a court according to delivery agreement. This document you can see on our website. And one more information, if you want to know how to file a lawsuit, how to file a claim for the delivery agreement. It is necessary to collect all source documents on the signed delivery agreement which confirm delivery of goods, its cost, and the delivery date. Usually, as such documents, consignment notes and invoices are used. Further, it is necessary to make the action for declaration, to calculate the state fee, to send the statement for declaration to the defendant, and to file a lawsuit, all the documents described above. After all documents are filed, the court will start consideration of the action for declaration. Aggregate term of consideration of the case in arbitration court is established by the law and makes in 2 months. There are 2 orders of consideration of such cases. It's a general way and some simplified. There are 2 ways according to Russian law. After the getting judgment, after the result of considering of the case, court make a judgment which must be compulsory be performed. And having a judgment, there are 2 methods of receiving the money. First of them, it's to send this executional list to the bank directly, because according to Russian legislation, you can take judgment and send it to the bank where account of defendant is open. And the second one is to perform the judgment to state services through service of court ushers. So I described to you shortly the way how to defend your company if the buyer of goods didn't pay to you for delivered goods. If you need such services in Russia, we are the Russian law firm. I'm a head of this firm. My name is Tarasenko. I didn't say it at the start of this video. You can send us request. You can call me directly. The phone number you can see in attached text or on our website, and we'll help you with filing a pretension, with filing a complaint to your partner, and also if the payment will be not get it, if money will be not paid, we can also file a lawsuit against the defendant and collect the money, and also we can provide execution of such judgment. See you in our office. Thank you for attention. Bye.